Hey there, Stephanie Joy with all things Social Security and the law practice of Joy Disability. Here's a short little segment from our recent live stream Q&A that we have every Wednesday at 1 p.m. Eastern Standard Time on the YouTube channel, All Things Social Security. Enjoy, and if you have any questions, leave them down below in the comments and I will be sure to get to them. Thanks so much. Bye-bye now. Hey, how are we doing today? People are just starting to pop in. I hope everyone's doing great. Hope you had a great week. It's only Wednesday, but half the week anyway. For most people anyway. Everything is good on this end. Busy, busy, busy as always. Mark says, thank you so much. You're awesome. Thank you, Mark. I appreciate that. Come back and visit anytime. And as Christina says, like, share, comment, and subscribe. Sybil says, appreciate your videos. Good karma for you. We could all use it, as much good karma as we can imagine, right? Sybil, I appreciate that. Kubi Dream says, I'll be 54 in October, worked 40 years. SSA says I have the 40 work credits. That's for retirement. That's not for Social Security disability, okay? You are permanently insured for retirement. Doesn't mean you know how much you're going to get for retirement every month. That'll depend on whether you win this case. It'll decline if you don't win this case or don't go back to work. The 40 work credits, guys, is what you need to get retirement. It's not required of younger people. It's something less. However, Kubi and everybody else needs is over like 30 years old or 31 is 20 earnings credits, Social Security credits earned in the last 10 years before the given month that you're saying you're disabled. All right. You know, you could look at this month and figure out, do I have 20 quarterly credits in the exact last 40 quarters, 10 years? And if it's like, I only have 18, I'm too short. You're going to have a DLI that is not today, it's in the past. Date last insured, DLI, our nemesis. Coob says, I'm looking at back surgery, T9, so thoracic and lumbar. Well, you're pursuing it. You're doing everything you need to do, Coob. Lawyers are working well with you, I think. And obviously, as you know, the trifecta you need for your age 54 grid, you have to be unable to do even light work. If they find you can do sedentary work, you're okay for prong one. But if they find you can do light work, you can't win right now. Well, you can't win under a grid. You could feasibly win the old-fashioned way with the proving all the 12,000 jobs with your RFC. Second thing, at 54, cannot do your prior job. That one also applies to everybody else. So what reasons medically can't you do your prior job? And the third thing, was that prior job skilled? If it was skilled, you have to prove that you cannot transfer those skills to the job that you could do in that exertional sedentary place that they say you're still able to do. So those are your 3-prong requirements there, Koob. But when you have musculoskeletal problems like Kubi does in the back and that are candidates for back surgery, that really does, I would say, go a long way towards diminishing that exertional that you need for prong one. It can definitely go towards kicking out medium, and sometimes it can go towards kicking back light if post-surgery or pre-surgery and post-surgery can't be on your feet all day long, which light work generally requires 6 to 8 hours. And depending on how fragile one is, despite the surgeries, maybe you can't be lifting 20 pounds at 54 years old. It's got to be, the doctor's like, no, you're really fragile. It needs to be like way under 10 pounds or under 10. So every case is different, but that's the gist. Things to think about. Gina says, got your 58 girl, maybe 38, but 58. Nah, keep up the great look. It's called filters, trust me. But I did start because I have this very sedentary life, and I can feel my joints and I can feel my stiffness and all that. I know when you get up there, use it or lose it. Once we lose it entirely, I think it's really hard to get it back. But anyway, I'm not quite there yet, but I definitely have seen over the last few years, and my sedentary nature of my lifestyle is not helpful. So how we say PT, physical therapy? I just started a PT. I made a significant investment, and it's all for health reasons and being independent mobility wise and stuff as I climb into my 60s. PT, personal training, it's semi-private, it's not private. And I just started last week. And I could barely walk some of the days. But it's getting better on my 5th day. So got to do what you got to do. I don't want to be immobile or in pain if I can help it. And I've already had more issues that I've remedied with self-taught. Google's your friend. Now it's chat, right? But gentle exercises after doing a bunch of research, and I cured a few other issues that will be recurring if I don't continue. So those things are coming along, and they're all caused by the sedentary this was neck and it was butt, truthfully. Butt from sitting so much and neck from being like a turtle like this. Hi. Or, oh, I can't see that screen. Oh, let me look at that medical record. It's so tiny. What does it say? Yeah. I got like that turtleneck thing. So I had to fix that. And it's much better, but it's definitely something that will occur again if I don't pay attention. So I try to pay attention. Lily La Rocho. Hello, Miss Stephanie. Everyone at All Things Social Security. I'm using my insurance agent profile today, so you won't see my usual Lily Flower profile. And she says to subscribe, like, and share. I agree. All right. Thank you. Good to see you, Lily. Rob says, do you work in PA? I am actually in PA. Yes, I actually do all 50 states, though, Rob. I am probably one of the few people that have done that for decades. I did it before people knew you could. Hey, fledgling startup lawyers got to learn all the things you can do. And that's what I did. So yeah, that's why I'm national now. And I don't even know how I could have done it if that wasn't the case. But yes, Pennsylvania, I'm in Pennsylvania. That's irrelevant for your purposes. And I came originally from Jersey. So I'd say half my people, it might even be just down to like 40% are from this area, because everything else is just all the other states I do too. Wherever you go, wherever you want to move is all good. It's all good for anyone who needs an attorney. You know, I think some of the more traditional law firms that tack on SSD work will say they're probably only going to do local because they don't really know that it's maybe that it's federal, and all through telecommunications, you know, how we get the information, all that, make the arguments, submit the briefs and all that. Although they're starting to catch on because now they're doing that in state court, but we've kind of been doing that for, I guess, longer than they have at the state level for other state work, which I used to do before I did this. Syndig says, thanks for your live stream and answers. You're welcome. So helpful. I'm glad. I hope they are helpful. 333 says, restrictions were temporary. Once medical determined conditions were permanent, I had to stop working prematurely. It doesn't matter. Those are in your last 5 years, so you have to get proof that you can't do the restricted work. If those were those are the most recent 3 years too. So, I mean, I don't know when they are, but when they scroll off the board of quit barking, please, the board of the 5 years that you are subjected to. And remember too, guys, if your DLI is in the past, your 5 years doesn't go backwards from today. It goes backwards from your DLI. So you don't get the benefit of the slowness after the fact. So if your DLI was 2 years ago, you got to go back 7. Okay. I'm so sorry, but that is the way that is. So 333 is spinal stenosis, arthritis, both knees, with general anxiety disorder, with insomnia disorder for years. Yeah. So if you're treating vigorously and very regularly, like there is serious interference in your life, each of those 3 things following up, you know, where it's appropriate, but then also getting the treatments that are available. I forget if you gave your vocational profile, what your past work was, and what is your current age. But I mean, those are serious things that will reduce the exertional for sure if you are treating for them like they hurt, like they are limiting. If you're not treating them as if they are, then that's going to work against you, obviously. What can be a beautiful thing is when in a DLI case, which is not the preferred kind of case, but if the past relevant work period passes with no jobs, but the way the year ended, you got those 4 credits, so you actually your DLI is in the past, but there is no, in the 5 years before that, there was no work, and it literally lined up. Then by the time we get to it, we're like, we can argue there's no past relevant work, and that eliminates the transferability of skills prong, as well as prong number 2. Can that person do the prior work? So that's something. And of course, that only works if you met prong 1, which means at whatever age you were at, did you get them to agree that you can't do X exertional level. So someone who's 54 has to prove they cannot do light work. They could only at best do sedentary work from an exertional standpoint. And someone who's 55 or above would have to prove less. They only have to prove they can't do medium and heavy work. So even if they do have the exertional capacity as stated by the SSA to do light or sedentary work, they could still prevail. They're just going to meet the other 2. Cecil's in the house. Hi, Cecil. Is that the captain? Hit the like button. Yes. Very kind of you, Cecil. 333. Okay, you probably told me that above, right? Unless we have a bunch of 58-year-olds in here. Yeah. I mean, I assume you have an attorney. What do they say? I mean, they're obviously going to hopefully try to steer you for your treatments that will produce the evidence that shows the limitations that would require to meet under the grids. That's the best avenue. If someone was disabled, this is Cecil. This is Captain Kirk. If someone was disabled at 3 years old and received Social Security, if you help them to be able to get a driver's permit, will it affect Social Security, fetal alcohol syndrome, autism, severe anxiety? Well, if one can get a driver's permit, it is obviously going to be considered because it's it's a skill they were able to achieve. Well, I shouldn't even say skill. It shows a capacity to A, take a written test and learn it, B, remember things, apply them, and then if they're able to be on the road and drive. A permit is when they're with somebody else, so they're not. It's not just a proof that they could drive alone. So let's say they have that severe anxiety where I could drive, but I just can't do it without my uncle or my dad or that I would make sure that was very evident. The therapist should be confirming that that's a problem. Maybe it's one you're working on, but so far, no go. So you want to show that driver's permit, if you get it, doesn't mean what it might mean for another person who got it that doesn't have a permit. So you want to kind of show how that, it does show that I could think, and it does show, the driver's permit, you never took that you never took this yet, right? So you just did the written. I say that, I think that's true because my kids all did that in the last couple of years. So it's not like they can say you have because remember, driving, there's so much of driving. It's pretty sophisticated capacity to do it. And it can cause a lot of anxiety. So someone with a severe anxiety, you might want to show, I can drive. However, my anxiety is so bad, I can't do it alone. I always have to have a chaperone, So think of things like that. Because driving is such a we are so, except for the bad drivers, our job is to be doing the operating of the car going forward while we're defensively looking at all the buffoons that are about to cause fatal accidents and trying to avoid them. And then follow the rules of the road. Like, what if the person got the permit or maybe even the driver's license, but their focus is so bad they keep speeding. They forget, the signage and don't realize they're going too fast. So their skills are really not that good and their attention span. But one would presumably think that they're going to lose that license in time due to points from all those speeding tickets. Or they can't remember that it's a one-way street and they get tickets for going down the wrong street in the wrong direction. Running stop signs is a harder one to defeat probably because you see it, unless they really don't see it. Then they shouldn't even have a license, right? But those are things like if someone gets a lot of tickets, the driving didn't work, got the license, don't know how, and then continue to lose the license because when you're actually on the road, all these tickets will come up, if you're driving. Jen Me says, SGA was all before 2019. I would, already passed that step in the sequential process. I'm talking about once that is all passed, I'm talking about getting rid of the 12,000 jobs, which are 9-to-5s. Do you have any past relevant work at all? Depends on your DLI is. That prior work, the non-SGA work is not prior work. So that's not going to show anything. It's really going to be about your current medical records. And the ones, if you're trying to get it to, it depends what the battle is. I'm trying to prove something 10 years ago, or I'm happy to prove it if it's yesterday. Yesterday's just SSI, but SSD would be if I can prove it back to 2019 or 2023. So it really depends what the goal is. And everyone's dates are all different. The past work is not going to establish the RFC today because it'll show if it was SGA, it'll show what your mental or physical RFC was able to withstand if it was sustained work back then. It doesn't mean it's not worse now. So medical records today can, improve on that. But remember, if it was sustained SGA work, that cuts off all the years prior. You've now recovered, and the only onset date that will be possible is after that last sustained work was no longer possible. You can't win back and then jump leapfrog over sustained SGA work. And I'm saying that generally, but I can't even think of an exception. Sybil says, I want to see if they got the third-party daily function report. And that's what you asked her on the phone, Sybil? I would take it as this. If she doesn't call to say she hasn't gotten it, I think I would go with she's gotten it. Did you fax it? Do you have fax confirmation? I assume you didn't fax it, but the third party did? Or your attorney did it for her or him? If it was mailed, presumably they mailed it certified return receipt. I will say if no proof they mailed it. So I could see why you might want to know if they have it. I would like to think that I will say this. Generally, if the person doesn't send it in the deadline, they send that person a reminder. So did that person get a reminder after the fact? If not, that's another sign that they got it. Is anything conclusive? No, because humans are
prone to a ton of errors. All of us, right? We just try to minimize them. Cindy says, hit thumbs up. Thanks so much. Yeah, for sure. I like it, guys. Like it. All right. Thanks, guys. Have a great one. Be safe.